Good day, everyone. I will continue with the second video, and as Debattata Rose already indicated, this second video will focus on supply chain responsibility in the context of the business and human rights debate. More specifically, I will talk about the supply chain concept underlying the UN Guiding Principles and what implications it has on the responsibility of companies, on the legalization process, and how it has shaped a new concept of supply chain responsibility. Why is this interesting? For one, the UN Guiding Principles introduced a quite novel understanding of the supply chain. And that is in itself quite interesting because it deviates from existing legal conceptions. For another, the supply chain responsibility. So how far are companies responsible in the global production is a core aspect of the UN Guiding Principles second pillar. It is not the only aspect. The central element is, of course, the due diligence process. But the due diligence process is also explained in how far and how one can make sense of it in the context of global supply chains. And finally, the concept of the supply chain and supply chain responsibility is an excellent example to show how the UN Guiding Principles have been providing the basis for entering novel ground in the field of business responsibility and legalizing it. How the concepts therein have managed to change public discourse and ultimately led to new types of conceptions of obligations of companies. It is again not the only one, but it's an excellent example to show the impact of the UN Guiding Principles. How do I structure the lecture? You can see this very well here in the slides. I will start with the first aspect, which is explaining supply chain responsibility. I will then continue with the legal significance, meaning that I will show how this concept of supply chain responsibility has been shaping public discourse, corporate policies, but also the debate on national legislation. I will then talk about what I call the implications of this supply chain concept, in particular to what type of debate it has given rise to in the context of the legalization process, what kind of novel problems, discussions, and contestations it has led to. And I will pick two particularly important aspects. And finally, I will end my lecture with outlining some alternatives or complementary aspects in which you can think about supply chains beyond the issue of business and human rights, which is often forgotten in the current debate that so much focuses on business and human rights and looks at supply chain responsibility through the lenses of businesses and the human rights responsibility. I'm starting with my first aspect, explaining supply chain responsibility. And here, of course, I am going back to the UN Guiding Principles that the first video has already been introducing in general in its history and its content. What I do find important, or why this is important for my lecture, is that supply chain responsibility is a core aspect of the second pillar. I have rephrased it here in the middle as basically the second pillar being about due diligence. That's the central responsibility of companies, but due diligence throughout the entire value chain. And I will get back to that and how that is exactly specified. Of course, it's not only in the second pillar, because the second pillar has relations to the first and the third pillar. Yeah? The second pillar lays out the business responsibility to conduct due diligence throughout the supply chain. But because the first pillar lays down the obligations of states to ensure that businesses respect human rights in accordance with the second pillar, it also means that states' duties also relate to providing policies, possibly legislating on making sure that businesses also consider their supply chain responsibility. And of course, it also has implications for the third pillar, because when we speak about having access to remedy of those that are affected by by business conduct. And if we define business conduct very widely in the second pillar, it has implications for who can be possibly affected. And that can now also include victims that have been suffering from negative impacts of the value chain. Of course, this is very much debated, in particular when as far as liability is concerned. Liability that can be claimed in national courts. And I will not discuss this extensively in the video, but I want to make sure to explain that this has, of course, also implications. So what are we talking about when we speak about supply chain responsibility? The UN guiding principles do not use legal categories. They do not distinguish between the company, the corporate group, the suppliers as contractual partners, and the supply chain as, let's say, the contractual network. They only separate between own activities and activities that are directly linked. And both are interesting for the concept of supply chain responsibility, because the principle 13.A states that companies have to avoid causing or contributing to adverse human rights impact through their own activities and address them when they occur, meaning that also companies can by means of actively managing their supply chains in a particular way, can qualify as their own activities. And the second aspect states that companies have to seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products, or services by their business relationship. This also is a quite wide understanding, which states that there's also a general responsibility of companies for activities by others. And what is more, the UN guiding principles, quite through the back door of the commentary to Principle 13, have introduced a quite wide understanding of business relationships. We lawyers may have thought that business relationships means that this concerns the direct contractual partners, but actually the UN guiding principles understand it to include relationships with business partners and entities in its value chain. So it also includes a responsibility for the entire value chain as part of the responsibility to respect. This is, of course, quite significant and quite vague, because there's no definition of what the value chain is. I will get back to that later. So what is interesting about the concept of supply chain responsibility? As I said, it is establishing a new understanding of how to think about the global operations of companies, because it does not distinguish in the legal way in which lawyers are used to think about the legal separate entity of a company and its relation in a corporate group, and then the supply chain as the contractual affiliation. It states that businesses have a responsibility of not causing, contributing, but so for their own activities, and these can happen in the value chain. And they're even responsible if it's not about their own activities, but they are linked. They're linked to it because they are part of a value chain. Yeah. The second important aspect is that it's a very holistic approach. It covers, now it does not state where the value chain ends and where it's beginning. It is just defining as the business responsibility for the value chain. And thirdly, of course, this could lead to a lot of critique because it's quite far-ranging responsibility of companies. But the UN guiding principles, and specifically in Principle 19, where the due diligence concept and the due diligence responsibility is operationalized and specified, there is an understanding of layered responsibilities. So the UN guiding principles also recognize that there needs to be a prioritization by companies made on what are particularly necessary risks to address, but also that, of course, different action is required when it is about the own activities that can lead to negative human rights impact or impact that is directly linked. And here, the UN guiding principles outline this concept of leverage. So even if a company has not directly contributed to a negative impact, it still has to use its leverage or increase its leverage towards those that are responsible. So this is more or less the concept of a supply chain responsibility in the UN Guiding Principles. What is the significance of this? So I'm going to outline a couple of aspects. For one, that concept has been very influential in shaping the responsibility discourse. So what are companies responsible? It has provided a framework for this, and I will just give two examples. One is the responsibility of banks, where there has been a famous debate between the Thun Group of banks and Ruggie in interpreting how the UNGPs apply to the banking sector, where Ruggie, as a response to Thun Group's statement, has been making very clear that even that financing companies that may only have contractual links to those projects that are financed can also be responsible under the UN Guiding Principles in the context of own activities, if they actively finance the projects. So there you can also see that this legal category of contracts that has lesser responsibility than the own business enterprise and the own corporate group has been relaxed through the UN Guiding Principles. The second example has been in the Corona crisis, the famous cancellation of orders by, in particular, textile companies due to the lockdowns, where a lot of public outcry was happening because that led to the cancellation of orders led to the disastrous consequence that suppliers often could not keep their employees, that they were partly running insolvent. And so that the exogenous shock of the Corona crisis, of the lockdowns, has been affecting certain parts in the value chain differently or more than others, resulting in a lot of public outcry against large corporations that were buying to take their responsibility seriously by also considering the impact that certain trading and contracting practices have on others, on their direct contractual partners, and the human rights impact that this causes. So that was one aspect where the public discourse could take place in this new concept of supply chain responsibility. The second is, of course, the shaping of national legislation. The due diligence concept has been legalized, as also the previous video has been showing, but it has also been legalized and in a manner to put the emphasis on regulating supply chains through due diligence legislation. And here, two examples where you can also see the differences is the French devoir de vigilance, which also has been extending the responsibility to develop and monitor, update a vigilance plan to controlled entities and direct business relationships where there's an established relationship. And the new German Due Diligence and Supply Chain Act that even provides a definition of the supply chain and the responsibility. And finally, you can also see it increasingly reflected in business policies, where business policies and related due diligence mechanisms cover the supply chain and spell out also more concretely how supplier codes of conduct that have been existing for a long time link to the overall corporate policies in the field of human rights. So this, you can see a number of developments that has been shaping the understanding of how far are businesses responsible for respecting human rights that extend towards the own entity and go into the supply chain. But of course, such legal implications or such implications can lead to new discussions, in particular when we're talking about the legalization of the UN Guiding Principles, no? And in particular the second pillar, no? In the supply chain legislation. And I'm going to focus on two aspects that I think are very important in the concept, in the discussion surrounding the legalization. As has been already described, the UN Guiding Principles second pillar is becoming legalized by means of specific piecemeal legislation that is developed in several countries, also in the EU. It is planned on making companies, creating an obligation for companies to conduct due diligence. And here again, we have specifically this discussion surrounding supply chain responsibility. How do we legalize this understanding of supply chain responsibility? And one thing, of course, is the responsibility of who is responsible. If we look at supply chains are made out of a lot of different actors and a lot of business actors, small enterprises, large enterprises, enterprises that are that have a lot of bargaining power, others that don't have a lot of bargaining power. And the UN Guiding Principles have been, by integrating the supply chain into the concept of human rights responsibility, have been, of course, setting the basis for a specific actor-centric responsibility. So it states that companies are responsible for their value chain. And this, of course, leads to the problem of who then are these actors? Who is and that is what is the debate at the moment? Who is a lead firm? Who is a lead firm that has a responsibility for the supply chain? The UNGPs have been leaving that quite open by saying, generally all business enterprises have a responsibility to respect human rights. And there, of course, it depends a bit on how strong that responsibility is in relation to size and capability. But generally, it is covering all enterprises. But when we get into the legalization, we now have new categories in national law relating to defining the lead firm. That is partly based on the size, how many employees, what annual turnover, and in what countries of incorporation or where is the company incorporated, is it then covered by the particular legislation, by the particular obligation? Does it have the particular obligation to monitor its supply chain? And here you can see huge differences. When you look at the non-financial reporting directive, which was the first, let's say, legislation that has been implementing the UN Guiding Principles, that applies to companies as of 500 employees and has normally a capital market orientation as a requirement. When you look into the French law, the devoir de vigilance, that only applies to very large companies, more than 5,000 employees or 10,000 worldwide. And the German law also had huge discussions on how far do we extend that law? What companies are covered? Now having the compromise that it covers employees as of 3,000 employees, as of next year, as of 1,000. But there again, the law now defines the business responsibility for supply chains as one that is primarily one for lead firms, and lead firms being legally considered those that are large. So the other interesting element is the definition of the value chain, the reach, as I would call it. Where does the value chain begin and end? Where does the responsibility for value chains begin and end? As I previously said, the UNGP are quite open, quite broad. They define entities in the entire value chain. Yeah? So that is also, of course, quite possible because it's a soft law framework, you know, that sets the basis, but does not need to make the hard distinction that a law has to make or a case decision has to make. And when you look into national law, you see new categories evolving where you see there's different decisions made. There are different debates and controversies about how much do you include into the concept of the value chain. So you partly have the definition of the value chain, where, for instance, the French devoir de vigilance is focusing on established business relationships. So it is a quite narrow understanding of the value chain. It says a company has the responsibility in relation to the vigilance plan is extended to those where the company has an established business relationship. Others are covering generally the first tier, such as the German law, and even or proposals that are going into the direction of stating it needs to cover all types of entities. So here again, we see that there is no clear-cut answer in how the EU guiding principles are going to be legalized and what the concept of supply chain responsibility actually entails. And here you can see quite some differences. So this on, let's say, the legal implications on the supply chain concept. And I will end, as I said, going a bit back from the UN guiding principles to the idea of supply chains and possibly alternative types of regulation. So alternatives and complementary approaches to regulating supply chains. Now, as I now introduced in the whole lecture in this short video, the UN guiding principles very much look at the supply chain, through the actor-centric perspective of the lead firm, establishing a responsibility of a company for its value chain. And second, of course, it is also centering around human rights responsibilities. So it's very instrumentally looking at the value chains and the responsibilities therein through the lens of human rights respect. And here we can think also of expanding that scope and having a broader look into how can we look at global value chains and also making global value chains more sustainable, ensuring stronger human rights respect beyond that corporate-centric perspective. And here I'm just outlining, and I'm finishing with two alternative or two complementary approaches that you can think of. One is, of course, the contract and contract law, because, of course, value chains are a set of interlinked contracts. So you, instead of saying we have a business and that business has a responsibility for the value chain, we can also think of establishing or conceiving of contractual duties. So relational duties between the actors in the value chains, relational fiduciary duties, for instance, where you can think of duties to cooperate, duties to fair contracting practices. And here you see the link partly in the legislative initiatives. When you, for instance, look in the German law states that part of the due diligence responsibility of company is also to ensure a particular form of fair contracting practices with their suppliers. So here you can also see the link, but that, of course, the contractual perspective goes beyond that, because it then also can go into how can these type of duties be enforced, who is liable if they are not adhered to, and who can claim that certain cooperative or fiduciary duties have not been upheld. It also, you can think, of course, of contract in terms of third parties. So when you think of those that are negatively affected by human, or by business activities or by value chain activities, the business and human rights debate would very much link that to the rights of victims and the possibility to claim compensation to tort law and to civil liability rules. Whereas when you look at the value chain and these types of cooperative duties through the contract, you can also look at it through the context of contractual liability, third-party rights. This is, of course, going very far, but there are debates in contract law on how to accommodate contractual third-party rights within value chains. The other alternative or complementary approach can be to look at certain practices in the value chain and certain way in which value chains are structured that are more prone to being unsustainable or affecting the rights or negatively affecting human rights. And here in particular, one clear example is trading practices, because of course, not everything that happens in value chains and all the contracts are made by the businesses. There's often standard contract terms, there's institutionalized trading practices, such as the type of payment, the period of payment, how are orders placed that are often not really negotiated by one company, but there are certain sector-specific trading practices. And these can be unfair, and these can lead to negative human rights impact. And here again, you could also think of regulating on this end and address these trading practices. And in a particularly apparent example at the moment is the EU Directive 2019-633 EU for specifically the food sector, where the EU has been legislating to have a review of trading practices in the food value chain, where one party that is affected can go and request that this type of trading practices is declared to be unfair and thus invalid. And there's also discussion, and this is where I will vaguely end with, and I encourage the further reading that I provide, is to think of a competition law for value chains, because value chains are a dominant feature of global trade and the global market relations. So one can also think on whether competition law needs to align to that and also make sure that there is a fair competition for value and there is less power asymmetries. This, of course, goes very far, and it also is a strong development in the law of contracts and the law of market regulation and competition law. But just to show also there are alternative ways in which you can link, in which you can think of value chains that are complementary, and that to the business and human rights debate and the corporate responsibility. And I think that the UN Guiding Principles have been opening up this debate, particularly because they have been specifying a concept of supply chain responsibility that was received a lot of attention and has been laying the floor for legislative initiatives. And with that, let's say, holistic image that provides, of course, a lot of food for thought and a lot of new avenues to think about supply chains, I will end my presentation, and I am thanking you, and goodbye.